Yeah.
So today we're looking at the AEMC work on the regulation of embedded networks. And last week, the AEMC released a new paper on embedded networks. I hope we can hear us okay. This webinar will go for approximately 20 minutes, and then we'll have an opportunity to ask questions. If you have any questions, you can either click on the Q&A button or the chat, and just be aware that when you do ask a question, if you type it in chat, that other people will be able to see your name. So I'm joined by Alex Silcock. You probably know who we are already. We have compliance quarter and law quarter. Our work includes a lot of work in the energy sector, applying for retail authorizations, advising embedded network companies and retailers. The image on the bottom left shows the number of retail authorization applications throughout the last 8 years or so, starting from 2012, which is when NECF commenced, and the yellow circle represents the proportion of those those entities that are our clients. So we've been around for about 16 months, and we seem to be picking up the majority of new entrant retailers. And so far, we've got 100% success rate. It's not all down to the work that we do. It's mostly it's our clients, and we're just careful about who we work with. We also have the Compliance Hub, which is our software program that helps companies comply and demonstrate compliance. And we publish regulatory updates, including on the AEMC changes, to make sure that our clients are aware of changes to the regulation. So we're going to look at the AEMC final report, but firstly, do a bit of an introduction to embedded networks and the national energy market, and how those rules are in place in each of the NECF jurisdictions. And that's what Alex is going to talk about.
Yeah, so when people talk about NECF, yeah, I guess they're speaking about the National Energy Customer Framework, which is really the suite of laws, rules, regulations based around consumer protection in the energy sector. And that's sort of implemented by law through legislation that was enacted in South Australia, the National Energy Retail Law itself is contained in Schedule 1 of the South Australian Act, and then picked up and adopted in the various other jurisdictions. And that essentially means that these rules are picked up as state law and enforceable as laws of the states wherever they're in place. Victoria, I think, has their own rules and haven't implemented NECF directly. The other important thing to note is that there are the jurisdictional derogations in each jurisdiction, and each state has sort of seen fit to introduce some specific consumer protections that they feel are most important in their particular region.
Yep. And can you tell us what is an embedded network and how does that currently fit within the regulatory regime?
So an embedded network, I guess, is, it's can be tough to explain, but essentially a network that is off the main grid. So privately owned networks that serve their customers within the embedded network through a parent connection point, so connected to the main transmission or distribution network. The idea is that they can provide some benefits to the customers within the network if they're appropriately regulated. So they can help manage energy costs and and I guess help operators and sellers be a bit more innovative in the product they offer to the customers within the embedded network.
Okay, thanks for that. So we've held previous webinars on the AEMC report on the 28th of November last year. The AEMC released its final report on the regulation of embedded networks, and the conclusion, kind of this catchphrase, was that the existing regulation was not fit for purpose, and they picked that term up from the AER's submission. The AER is the regulatory body who provides exemptions and authorises retailers. The AER's concern was that there are a much larger number of embedded networks than that were originally anticipated. They estimated in the AER report that there's around about 200,000 embedded network customers. I'd suspect that it may be higher than that. The number of exemptions, which you can see on the AER's website, has risen from 147 in 2012. In 2016, it was 1,358. And we think that there's probably about 3,000 to 4,000 exemptions currently on the register. A lot of new embedded networks being established in your apartment buildings. Alex, your own apartment is within an embedded network. We sort of keep them accountable as to their obligations. But there are also lots of embedded networks that are probably embedded networks that have no idea about the regulatory obligations and are not registered and should be. Last year, we saw Stockland fined for not having the correct exemptions. I think the fine was about $40,000. But recently, we've also seen a lot of embedded network operators become authorized retailers as well. And maybe, Alex, you want to explain sort of generally what are the differences between an exemption and an authorization in terms of the application process, and a bit of a harder question, the actual obligations that apply?
Yeah, I guess the application process, put simply, is a lot easier in terms of applying for an exemption. There's still a sort of a consultation period that you have to go through, and certain information you have to provide the AER. Stakeholders get a chance to make comments and such, but compared to the retail authorization process, where the AER will sort of look at three particular criteria, one of them being financial capacity, another organizational capacity, and the other, I think, good financials, and good character, proper character to hold an authorization. In general, the application process for the license is much more onerous in terms of not just the financial information you've got to provide, but also to show you have the technical capacity. And that's often where we help, I guess, in terms of providing those policy documents and showing that our clients have that good understanding of the energy market. And I guess in terms of the different obligations, it can be hard to sort of summarize, but yeah, in general, I guess the main takeaway is that authorized retailers are under more onerous obligations than exempt sellers. Really, customers are practically they're given greater protection if they're outside, if they're supplied by a retailer, an authorized retailer, rather than an exempt seller.
Yep. So the concern of the AER was that discrepancy in the level of regulation that embedded networks have, and also the general concern that a lot of them just simply have no idea of what their obligations are. And the motivation of the AER is to make sure that all energy consumers have the same level of protection. They're probably the three main areas that the AER are concerned about generally are customer hardship. So that's a customer not having the capacity to pay. And there are lots of protections that apply to under the authorization framework, and they're going to be strengthened yet again. But do exemption holders have hardship programs? Most likely not. The other main area is explicit informed consent. So the concept of making sure that a customer knows what they're getting into. And I know that, in your case, Alex, when you moved into the apartment block, there wasn't really much of a process of obtaining your consent to enter into a contract. It was just like, here is the contract for your building. And then the third one is power of choice. So the concept that individual customers should be able to choose their own retailer. So the AEMC report recommended that there be a complete overhaul of the existing regulatory framework. There was also a report produced by Mint Ellison as to how they might implement those changes. And we say that the two documents are probably worthwhile reading if you're operating in the space of embedded networks. So the new regulatory approach is that they're wanting to improve access to competition, which is power of choice, as we've said. They want to elevate embedded networks into the national framework by including minimum obligations and protections for new embedded networks. And they want to have better regulation of what they call legacy embedded networks. So for existing providers, existing buildings that operate under an exemption, they would be classified as legacy embedded networks. Is that correct? Yeah. So legacy embedded networks would retain their exemptions. This is the proposal that hasn't been finalised yet, and would continue to operate under the exemption framework. New guidelines are going to be introduced to improve consumer protections, monitor and enforce exemption holders, and embedded networks, as is already starting to be the case, are going to need to be members of the ombudsman schemes, and there's going to be more protection for life support customers. New embedded networks are going to still be able to operate, but the majority of them will need to operate under an authorization, which is the more onerous of the two options that Alex spoke about previously. There will still be some exemptions, but they'll be reduced. And the types of exemptions that will apply will be sort of infrastructure, like electric vehicle charging stations, short-term accommodations such as caravan parks, and larger customers who are in a position to negotiate directly. So this is an extract from the Mint Ellison report, and it talks about how they'll achieve that change, that transition. And what they're looking at doing is establishing a new category of network service provider and a new class of retailer. What that means is that a lot of existing exemption holders, if they want to take on new embedded networks, and we'll get into what that actually means a bit later on, are going to need to become authorized retailers. And so they'll need to go through that process. So the timeline, we had the final report in November last year. And last week, the AEMC released a work statement. And basically they're saying that their final report is going to be due by the 31st of May next year. And that will include a package of changes to all of the regulations to give effect to the recommendation. That will apply not only in relation to electricity, but also gas. And it will apply not only on the retail side, but also on the network exemption side. So some common questions that we get, what exemptions will continue? So the two main ones are electric vehicle charging stations and all those other like sort of incidental type services that we spoke about earlier, and legacy embedded networks. Alex, you want to talk about what's the difference between new and legacy embedded networks?
So I guess, yeah, legacy embedded networks are those that have already been established pre the changes. That's my understanding. And yeah, new embedded networks will be those established after the rules are implemented. Yeah, so I guess you could say the legacy embedded networks will be grandfathered through and not subject to the same obligations as any new networks that are established post the rule changes.
Yeah. So the Mint Ellison report talks about what they're going to do with these grandfathered embedded networks, and they give a few options. One option is that the grandfathering will continue forever. Other options include that the exemption will be lost once there's a change in control of the owner of the holder of the exemption, or if there's a change in ownership of the building to which the exemption attaches. What we'd say is more likely than not, I'd say that they'll choose an option that doesn't cause too much disruption for those customers that hold that are within embedded networks supplied under an exemption. The other question is, what about power purchase agreements? So we've been doing a lot of work on power purchase agreements lately. They're saying that the power purchase agreements is really just a type of energy sale, but it's not a particular type of energy sale that they identify as being exempt from this new requirement. So PPA providers may require an authorization as well. And then lastly, what should existing exemption holders do? This has been a question in terms of, you see, some larger energy companies that hold authorizations and exemptions for different types of activities. The AR's general push, particularly recently, in our view, I'm not talking for the AR, but they don't like that concept of a company having an exemption and an authorization and sort of picking and choosing which one they use, because from their perspective, an authorization provides better protection for consumers. So under the existing rules, the AR has powers to basically do what they want to do in relation to existing exemptions. Most likely, I don't think the AR would seek to withdraw exemptions or revoke them, but it would be the case that those companies that sell energy that are relying on exemptions at the moment, they transition to authorized retail operations would surrender their exemptions. And then there's sort of consequential questions about, well, what does that mean in terms of do you require customer consent to be able to transfer from the exemption to the authorized retailer? But we'll get to that when the time comes. Anything else on that?
No, not too much. I guess it's just until we see these draft rules when they release them in May, we won't be certain of exactly the obligations that these new authorization holders will be under. It's potentially they'll be the same obligations as current authorized retailers, but there could be that middle ground where they're under stricter obligations than they would be if they were under the current exempt selling regime, but maybe still at that level below what a current retailer is required to satisfy.
All right. So that's the end of our presentation. If you've got any questions, we don't have any questions in chat, which is a good thing, but you can just email me or Alex. Alex is just alex@Compliance Quarter. So we have the law firm and the compliance business. In the law firm, we do the traditional legal work, legal advice and so forth, but in compliance, we just keep our clients updated as to these changes. And as I said earlier, we've got the compliance hub, and that kind of packages it all together. And, from the perspective of the regulator, they want to see energy businesses that are on the front foot and that are, they don't want to see a bare minimum level of compliance. They want to see customer focus. So we're always happy to help with that type of work. But thanks for joining us today. If you've got any questions, email it through, and have a good day.